Yes, we were talking about now the oral testimony portions of expert witnessing. And we're talking about the role of the expert. The role here is being available for a deposition and for trial. The deposition is a meaningful event in the sense that it is exactly like the trial, but it's not in front of the jury or the judge.
Could we consider it for rehearsal?
It is.
Fact-finding on the part of the opposing counsel?
I want you to think about it as a dry run for trial testimony. And the closer you are to that sense of dry run, the more impressive you would be to the person who is asking you the questions. Remember, you're called as the deponent by an attorney who is asking you questions. You may hear those same questions or better questions asked of you at the trial, and your responses are being evaluated by the attorneys, both of them, to see how you bear up. Can you defend your answers? Will your answers impress the jury? Basically, that question is, will your answers be believed by the jury? Will the jury believe you? Are you a credible witness? So in the deposition, the basis of your opinion, your qualifications, and your opinion itself, those three things are going to be the subjects focused on in the deposition. Now, is a deposition necessary? Will anyone take it? Are you allowed to ask for payment? And the answer is you are allowed to be paid. You can demand to be paid. The person taking your deposition has to pay you your rates that have been designated by you through the attorney who is defending. And it's like a mini trial. And of course it's under oath. It's in front of a court reporter. Now, that court reporter can be waived. You can have just a videotape or an audio tape of a deposition. You can have a statement made by somebody who is not a court reporter. But those would be, they would require a special stipulation. The farther away you get from a court reporter and an attorney asking you questions, the farther away you are from the formal discovery technique of taking a deposition.
Are you also further away from credibility or believability?
No. You might be, these are just different techniques. One is...
Now, I have given quite a number of depositions in the past few years.
Well, you gave them, in a sense. You gave your testimony.
Yes.
And a deposition was taken of you.
Okay.
So, your deposition was taken.
My deposition was taken. And my experience is, as long as I stick to what I really know, and as long as I don't get far or at all beyond the documented facts of the case, I can, through ordinary credit-related, credit-used documents, establish when the first late payment in this matter were. I can establish, without a doubt, how many of those late payments there were after that first one. I can establish, were they all payments after that date late payments, or were they intermittent? I can establish if there were late payments prior to the injury. And I can do that not only through the credit report, I can do that through some of the monthly statements. And one of the ways that I can do that through the monthly statements is I look at the late fee. Not all creditors report with pristine accuracy what they should report, but they all want to collect the fees that they can get for a late payment. They all want to collect as many fees as they can get from the borrower. So your sole source is not the credit report. Your most comprehensive source, if you know how to read it, is the credit report, because among the three credit bureau reports, TransUnion, Experian, and CBI Equifax. Among those three reports, you have the most possible complete picture of an individual's credit behavior. That is the best way to look at the huge picture, overall picture. If you only use monthly statements, you're only going to get information from one account. I probably went off a little too far on that.
Okay. Okay.
I've also, Tom mentioned a few minutes ago, the elimination of advocacy. One of the cornerstones, one of the major basic requirements that has been drummed into my head for an expert is do not become an advocate for your client. Do not adopt your client. Do not feel sorry for your client. That's not your job. Your job is to collect the facts in as neutral a way as possible, from as neutral a source as possible, and take that information and present it to the judge or the jury or the arbitrator and let them use that information that you have simplified, that you have organized in such a way that it becomes clear what the pattern of behavior was at any point. That's a cornerstone of credibility. That's a cornerstone of believability.
That is an important distinction here. The expert is not the attorney, not the advocate, and the jury doesn't, the jury expects attorneys to believe in their clients and to be advocates and strongly advocate for them. The role of an expert is much more effective if it appears to be scientifically neutral and detached. Not to say that the source of information is necessarily neutral. The evidence may be very favorable to one side or the other.
Of course.
But it may be that the evidence is that there is zero credit damage. And if that's the case, you're either you better be on the defense side, or you may have to withdraw from your representation as an expert, because you can't claim that there's some damage when there isn't. Now, testifying as a live witness, you're either in deposition or an investigation, informal type. I do want to comment about what a deposition is. Attorneys will use the phrase discovery, and it's a wonderful phrase because it's one of those descriptive terms, but it has a very technical meaning to attorneys, as well as just what we think of the description of discovery.
Christopher Columbus?
For an attorney, it specifically means one of the forms of statutory ways of obtaining information from the other side or from third parties. For example, what we call interrogatories, and that's questions between the parties. Inter being between and rogatory being questions. They're not like questions. We don't use the word questioning because that would, you'd be questioning anyone. Interrogatories are questions propounded to the other party, parties to the litigation, not other people. You may be, as an expert, very helpful in terms of helping your clients, the attorneys, answer the interrogatories for the client, because interrogatories can explore not only the facts of the case, but also the theories of the case. And form interrogatories specifically ask, what damages have you sustained? You want to jump in there. You want to be there answering those interrogatories, helping get your measurement, or if you haven't finished your work, you want to be sure that the attorney has responded to that question of what are the damages and how did you measure them, by saying we are still working on that, we're still measuring And what we'll be doing is measuring the difference between the before and after the credit reputation, the impact of the wrongful act on the credit reputation. Now that's interrogatories. Another form or type of discovery is notice to produce, and that's the request for documents. This is basically to prevent the trial from becoming a sandbagging exercise where you surprise the other side with documents that they've asked for. In other words, you can surprise the other side with documents if they never asked. And that's called impeachment sometimes. But if they ask, if they say, look, we'd like to have a trial, we'd like to ventilate the facts, we want to know what the dispute is about, what documents do you claim are in your favor or are you going to rely upon at trial? They're entitled then to get those documents, and you should be a part of that, or just be aware that there may be a request from the other side to have the documents you based your opinion on produced so that the other side can see them.
And in that vein, if you suspect that there's any possibility that you're going to testify based on those documents, or you're going to be asked to produce those documents under discovery, I believe that you want to make sure you're using the right documents. And the one document that more often than not is misused is a consumer credit report versus a subscriber credit report. I have impeached and neutralized more experts because they didn't know the difference between those two simple kinds of reports.
And remember, the big difference is that the lenders don't rely on the consumer report at all. They're not making their risk assessment or their determination about whether or not to extend credit based on the consumer report. They're not basing their decisions on it at all. So it's you want to be sure and get the document that they are basing their decisions on.
Otherwise you have no foundation.
Now another form of discovery is the request for admissions. This is another wonderful tool, often done after the interrogatory responses have been analyzed. And you look at the responses and determine what issues are ripe for admission and which ones aren't, that you just want to poke at the other side with and see and make them deny them, and match up the request for admissions with a request for all documents that support your denial of an assertion of fact. That's the twin, and this is easily done with Form Interrogatory 17.1. So reserve 17.1 in your first set of form interrogatories to be sure that you match that one with a request for admissions when that's time to do. Now, as the expert, for example, one question to propound to the other side, one admission would be, do you admit that you have caused credit damage? Do you admit that there has been a credit damage of $50,000 in the withdrawal of credit from Wells Fargo? Some specific fact. Always be sure to include a time frame. And if you have a request for admission that does not have a time frame, like any discovery, always make sure to clarify what the time frame is. You want to get your response in and object to a question that doesn't have a time frame. In other words, be a little surgical. The attorneys are entitled to, they're accused of parsing these things too closely. What they're trying to do, or what the court is trying to get at, is very clear, clean evidence. We want to find out exactly what the truth is. Sometimes the truth isn't exact. It's something that you can't twist out of or distort. Now, there are other forms of discovery, basically requests for inspection. Often, this doesn't come up too often in credit damage other than to inspect the reports. Now, why? And this is because without the permission of the consumer, no one else is entitled to look at the credit reports. But what about subscribers? Can they look at the credit report?
They're not supposed to. They're absolutely not supposed to. Subscribers are only supposed to have knowledge of their own account unless they've been given by the consumer or borrower or applicant to look at the entire picture.
Now, typically, do lenders obtain a consent to look at the credit report even after the initial loan application?
Absolutely. It is common, and I think more common today than previously, that 2 credit reports are pulled on every credit application. The first is at the point of application, and the other is within 24 hours of the issuance of funds, because things change.
Things change.
And they don't want to be caught with the revelation too late that they just gave you a check of thousands of dollars, and you have 26 collection accounts, which just showed up within the last week.
Now, I enjoy trying to keep the broad picture in at the same time as we look at a specific case, and I don't know that it's necessary to do that, but most of your clients today will be suffering financial distress. This is because almost everyone is now. If they are middle class, they are suffering financial distress, very likely. And this is because of the broad collapse of financial institutions today, the withdrawal of credit, and unemployment figures rising, hardships that were not as apparent maybe 3 years ago. Although credit was, most of the appearance of prosperity was actually built on credit. The significance of that is that both governments and private consumers were building huge credit obligations, unprecedented in history. Not just the government, private consumers and the middle class had never become so indebted. What appears to be prosperity was actually built upon credit. The credit card companies developed new types of credit product that were convenient and well marketed, vigorously marketed, so that people were buying things over time that were worth it to them, which they never could purchase. They could never actually own, but they were able to acquire. And this works quite well. But people now with 2 earning spouses were able to appear to have more things than back in the days when only one spouse was earning money, but they had no debts. Now you had 2 people working, and they couldn't pay off the debt that they had.
Only if they only pay the minimum amount.
That's true. Now, the significance of this is that we start, as you testify, you're also going to be wanting to keep the big picture in mind. It is there. It is the frame in which your particular client is struggling to come out. And the big picture will be used against you, no matter which side you're on. The big picture is a kind of excuse for behavior. Now, in testifying, the jury is participating in that bigger picture. They don't necessarily feel natural sympathy with a victim. They may have many reasons not to. They may be threatened by the victim. They may look down upon victims. They may look down upon predators if you represent a predator. In other words, this is a place where the big picture is going, that the jury, in a sense, is sitting in their own little framework. and you have to negotiate the kinds of prejudices that they feel and that they are themselves experiencing. If you are appealing to the jury because your client has suffered credit damage and your entire panel of jurors has also suffered credit damage, and they're not whining about it, they're bearing up, they're not trying to sue anyone, you need to really look at what's going on. As an expert, we want to suggest that you have to go in and fight for the rights of victims. Remember, our law is built on the fact that the detriment, the victim may recover compensation for the detriment caused by the wrongdoer. The victim has to seek that compensation. It is not given to the victim. Nothing is given to victims. They have to seek it, and you are the means for this recovery. Okay.
I just wanted to stipulate again that you are the vehicle, the conduit, the explainer, the verbalizer, probably a better word. While you're doing all this, while you're explaining how their credit was damaged, how they have suffered, how all of these problems have been inflicted on them, you have to do it in such a way that you are not advocating anything.
Yeah.
You are not advocating. Yes, it's too bad Mrs. Jones lost all of her credit cards. And it's my opinion that the value of her credit cards was $100,000. And because of that, I believe she's entitled to X number of dollars in compensation. That's not advocacy. That's an opinion. And it's an opinion based on facts, on documents which are irrefutable.
I like the irrefutability thing. Now, let's talk about lying and deception. We just experienced a financial collapse, and the major financial institutions of this country, and in fact they were copied and emulated throughout the world, not universally, but in many parts of the world. What was missing? What did we suddenly lose in October 2008, and starting a little earlier that summer? Did a bunch of gold get lost? Did we suddenly become poorer in diamonds and platinum? Nothing of value was lost. Not a single city suddenly disappeared. And yet we suffered tremendous financial loss. Did they burn money? Was cash suddenly gone?
No, but bank accounts were substantially reduced.
What disappeared?
Value.
One thing disappeared. Credit.
Well,
The appreciation of property and the credit, this substance that is not material but is valuable, and that is many times more valuable than all of the gold put together. If you took all the cash, the credit exceeded the amount of the cash that was in circulation. The credit disappeared. Banks stopped giving credit. They didn't give it to each other. They didn't give it to consumers. They didn't give it to business. They still aren't giving it to business, and there may be political reasons for that. But credit is what disappeared, and credit is what was removed by predators in a not a free market, but in a market which had been taken over by predators. Now, we can describe that in different ways, but there is no one that disagrees with the fact that what was taken away was credit, not gold, not piles of cash. Now, do you see the difference between cash and credit? What is the equivalent? As an expert, you're looking for that equivalency. If $50,000 in credit is removed from someone's bank account, from someone's life, how equivalent is that to $50,000 in cash? Suppose you go to the judge and ask the judge or jury to award $50,000 to replace the $50,000 cash to replace the $50,000 credit that was withdrawn by a lender in a withdrawal letter. How equivalent are those two things? Is it wrong to ask for $50,000 cash to replace the credit? There are some who argue that the credit is worth more than the $50,000 cash. There are some who think that the cash, if you ordered the defendant to replace the lost credit with $50,000 cash, that's a windfall to the victim. This is the study, this is why you're students, and this is why we're looking at this problem today. Many judges still, and many attorneys, there's a resistance to looking at the equivalence of money and credit. Just like when Melvin Belli first wrote a law review article seeking an equivalence of cash to compensate people for pain and suffering. You know that this is apples and oranges. They're not the same. Money is not the same as pain and suffering. You can never replace Rockefeller's stomach with money. If you had all of his money, you couldn't do that. You know, we need to reconcile this concept that you can seek compensation for the detriment caused. If you have ascertainability, if you have a method that enables you to repeat it, and someone else can arrive at the same number using the same method, and if you have the expertise to read the correct documents, the documents relied upon by the major financial institutions in making their decisions about what is worth something, and you know that a bunch of predators made a pretty savvy decision about what is valuable, they disappeared trillions of dollars in credit. They left the cash untouched. They left the gold untouched.
Well, I don't think that they disappeared it. I think they acquired it. I think they took an elder person who had nominal income, whose house needed some repairs, and who wanted to do something lovely for the grandchildren, and said, hey, if you sign this document, I'm going to give you a lot of cash, you can do all these things you want, and never mentioned that the borrower had $100,000 in equity in their property. That's what they liquidated. That's what they took.
They took equity, in other words, they took the credit that was extended, securitized credit. Now, as the expert, we don't want you to overreach, we don't want you to speculate. We teach a methodology for measuring. We teach a methodology for calculating the monetized amount based on the monetization that derives from a credit report that the financial institutions themselves are using. Now, we're touching upon ethics, and as we talk about testimony, let's finish up. What we're looking at is the most important aspect of this expert is his credibility, that he tells the truth, that she is credible to the jury, and the jury sees her as a truth teller. That is what is going to be the most helpful and the most influential for the jury. The facts that you rely upon have to be complete. You can't deliberately select facts, hide facts. Concealment is a form of fraud. If you base your opinion on partial facts, you never really got the documents that you asked for. To tell the complete truth, you may have to tell the jury, even if no one asks, that you based your opinion on a partial display of the fact of the documents that you requested. You may have a duty to do that. I think you have that duty. Why? Because you are taking an oath to tell the complete truth, whole and complete. It's not the complete truth if you have withheld something that you based your opinion on. It's not complete, even if you weren't asked. Now, lying or fabricating a story is obviously abhorrent to the jury, but and as an expert, is there a law that says you can't lie? Suppose you don't take an oath, you're just writing your report, and you want to get work, you want to get a job, and so you're willing to prostitute yourself. And I shouldn't use that phrase because that demeans what is comparatively a respectable profession compared to predators. But lawyers who might be hiring you have some interesting ethical responsibilities on their part. And I think many people don't realize that lawyers have an ethical obligation to tell the truth. A lawyer who lies is violating the rules of his profession. And this is basically Rule 8.4, and each state has a code that also requires lawyers to tell the truth. Basically, it's worded sometimes a little funny, but let's go through the kind of misconduct that will touch upon your role as an expert, but that lawyers have to comply with. Lawyers in California, the Rule 8.4 is the rule of misconduct. And it says it is professional misconduct for a lawyer to A, violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through acts of another. Who's this other do you think is being alluded to here? Possibly you as the expert witness. In other words, if the lawyer is inducing you by paying you, by offering to pay you more, oh, your testimony is very valuable to us here because we want you to, well, we need you to show that that plaintiff has no credit damage.
Well, what they're really saying is, as an expert, you have a lot of power. As an expert that has a good appearance, sings well, is able to assure or comfort a jury or a judge that they're telling the truth. Not just ordinary truth, not the truth of a 10-year-old, but the truth of a professional who has organized information that is valuable to the outcome of this transaction event, this case. When the lawyer says to you, I want you to tell the jury that the defendant was guilty, that the defendant did the wrongful acts, that's improper. That's a misconduct. When the attorney says, listen, I know that you're going to come in at about $25,000. Can't you come in at like 60 or 70? I need a new condo in the Bahamas.
He's not going to be that express, but
Well,
it will be fiendishly subtle.
and they will say to you, hey, you know, the only way you're going to be valuable to me and the client in this case is if you come in at $70,000 or instead of $40,000. Well, that's not a measurement or decision for the expert to make. The numbers are what the numbers are. As a very good lawyer friend of mine says, it is what it is. You can't change it. 2 and 2 always makes 4. And you can't have anyone push you off of that pinnacle, that platform of reliability, of confidence, because without that, you're out of business.
And there are ways, there are professional techniques for being able to get in and avoid any appearance of impropriety or that invitation that indicates that you want to have a moral dilemma presented to you and you're inviting some compromise. The second list here of misconducts is to commit a criminal act that reflects adversely. Now listen, criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Now, are you going to be compromised by, say, an attorney who is drunk? Perhaps a drug, under the influence of a drug. Are they compromised as a lawyer in other respects? It's still criminal to, be drunk in public in some places. I realize that fitness as a lawyer sounds a little vague. But the functions of a lawyer are very clear. They're not vague at all. He's a representative. He's an advocate. He is a fiduciary. He has to fight for the interests of his client against his own interests. That's not unclear. That phrase is not vague. Fitness as a lawyer in other respects. Other respects, not just in the criminal act, but lawyers can't commit criminal acts. Now, is it a criminal act to assist a client in perpetrating a fraud? Almost all frauds are crimes. Okay? Almost all takings of the property of another are crimes. Larceny is broadly defined. It's inclusive of concealment. Suppose a lawyer drafts an instrument, a securitization, that is used to defraud investors as well as homeowners. And the lawyers actively drafted this instrument, knowing how it would be used, knowing that it would be marketed to consumers. Has the lawyer committed a criminal act or assisted another in committing a criminal act? Would you, if you were asked to testify on behalf of this, as the expert witness for this lawyer, to deny that a consumer had suffered any credit damage, or whatever, even if your calculations were correct, you may be, sitting upon the horns of that ethical dilemma of whether or not you're actually assisting him in misconduct. Subsection C is please listen to this one. This is the one you have to cite. This is Rule 8.4, subsection C. An attorney commits misconduct if he or she engages in conduct that involves dishonesty, fraud, deceit, or misrepresentation. Now, fraud, deceit, and misrepresentation are all species of the same type of thing, where you have deception, you have basically, this is the conqueror of the free market. This is the act that spoils the free market. This is the act which deprives the market of its ability to make the choices, the price determinations that are so important. The free market makes those decisions. But if the market is predation, if it's distorted by criminal activities or by deception, by consumers who are not making informed decisions.
Or misinformed.
Right. Their decisions are distorted. They can't make correct decisions. Either force or fraud or fear. It's a distorted market. We have taken away the most powerful tool we have for liberty and freedom. We've lost our free market. Engage in conduct involving dishonesty, fraud, deception, misrepresentation of facts. Lawyers cannot participate in that. They cannot engage in that conduct. If they ask you to participate with them, you would be placed into an ethical dilemma. You will have to live with that and be able to explain and think about getting through it. You can't really be an expert if you start engaging in dishonesty. You're simply not an expert anymore. What are you?
An educated fraudster.
The next one here is D, engage in conduct that is prejudicial to the administration of justice. Justice is an abstract concept. I never can forget how one of the great speeches about justice was made by Saddam Hussein, as after he had already demonstrated that he was a tyrant and a criminal. He had killed lots of people, murdered them, poisoned them. He savaged large populations, and he got up to his parliament and gave a great speech about justice. Justice. He invoked justice. We don't get away from this. It's universally understood. We dream. Everyone dreams about having justice. Even these criminals. You can go to a prison, and I encourage you to. Go to the jails and talk to people there. Talk to the people who are serving time, who have been convicted. If they claim they're innocent, doesn't matter. Talk to them and ask what they think about justice. Justice is universal. You can't get rid of it. We seek justice. You can't stamp it out. It's not delicate. It's not endangered. We all are trying to get it. The Libyans, after 40 years living under a tyrant, still want to have justice. It's not long enough for them to live in oppression. They still remember and long for justice. An attorney who engages in conduct that is prejudicial to the administration of justice. How does it happen that crime continues to happen? Who is enabling the criminals to flourish? You think it's the lack of government? You think it's too much government? No. It's probably, too many criminals. How do we get criminals to thrive? How do they create the environment and, the petri dish where a criminal, a predacious person, somebody who really likes to take stuff for nothing, he wants to get it for free, he doesn't want to pay for it. He wants to distort the marketplace. He wants to tilt the playing field in his favor. How does he create an environment where he can flourish? He goes to the attorneys, doesn't he? How could he do that today without the help of attorneys? Administration of justice. Justice is something that has to be administered. It needs laws, it needs constitutions, it needs people to fight for justice. Not talk about it, but to do it. And to measure the detriment that wrongdoers cause. Now, E is to state or imply an ability to influence improperly a government agency. Now this is what is called misconduct. To state or imply an ability to influence improperly a government agency. Or to achieve results by means that violate the rules of professional conduct or law. And F is knowingly assist a judge or judicial officer in conduct that is in violation of applicable rules of judicial conduct or other law. Now, lawyers, these are just the rules of professional ethics for lawyers. But the one that you as a non-attorney, if you're a non-attorney, and attorneys can be assessors, but this unlicensed practice of law issue also comes up, where we don't define exactly what lawyers do. It's really the only it's a misdemeanor to practice law without a license. It used to be a felony, or in some jurisdictions it's still a felony. But it is the only misdemeanor that really has no definition. We define many crimes to the point of embarrassment. Many sexual crimes, it just shouldn't be read in public, the definitions of these things. It seems gratuitous. But we don't define what exactly unlicensed practice of law is. We don't go beyond the fact that it's what lawyers do. In California, we have a troubling, let's not call it problematic. Maybe it facilitates transactions. Maybe it's a healthy and robust relationship between attorneys and other professions. But, for example, in the lending industry, the lenders will promote and market legal forms that have been prepared by lawyers. They will talk about these forms and sit down with the consumer. The consumer doesn't have a lawyer next to him, or with him, or on his side of the table. And the broker or the loan lender who's marketing these obligations will present these legal documents, many of which I have seen securitizations that are over 50 pages in length. Most of them are probably closer to 30. The consumer rarely understands them, rarely understands what the language means. They don't understand the terms of the loan that they are placed into. Is the broker practicing law without a license? Is the attorney who developed these new forms of obligations assisting the brokers in practicing law without a license, especially in the context of presenting a consumer with these legal obligations that the consumer has no counsel? This is an ethical issue. In this last round of the mortgage collapse, the consumers almost universally had no attorneys representing them. They came to courts, or now they come to court saying they want out of these obligations that they did not understand. Should they be allowed to get out? As an expert, you're measuring the damage they suffered as a result of being placed into obligations they did not understand. You have no opinion in that field. That's outside your expertise, isn't it? You're not a lawyer. You're an assessor. You're measuring the damage that is caused. You have no opinion. Don't step outside your opinion about whether or not there was practice of law without a license, whether or not there was the consumer should have had an attorney, whether or not the consumer understood the terms that you yourself probably can't understand and can't measure. I've had experts come in from the banking industry testifying about how much an option arm was worth. I had to have these experts come in because the assessor looking at the damage could only measure the damage. You needed an assessor to measure the credit damage, but we had nobody we needed an expert also to say how much the obligation was worth. Nobody could figure it out. We had experts who disagreed on how much an option arm is worth. The industry has yet to come up with anyone who's actually paid an option arm off on its terms. These are things that became so complex that no one could calculate what total amount would be paid if it was paid on its terms. The instruments are designed to refer to events in the future that we have difficulty liquidating, or it may be impossible to liquidate. They were designed as foreclosure devices, not as loans. Now, do you see how that mixes with your testimony as the assessor? But it's different. You don't need to go outside your expertise, and it would be inappropriate for you to go outside your expertise. Don't be drawn into political or expertise outside your area. Economics might be outside your area.
Accounting would be outside your area. Real estate transactions, the ability to perform those would be outside your area.
And my point is that these other areas are important, but they're outside your area. In other words, they may be critical. I think it's very important to have facts and expertise brought to bear in the many cases. But what we're training you tonight to work out is the assessment of the credit damage, the impact on a consumer's asset of their credit reputation.
And a business.
Or a business's credit reputation. Can a business have a credit reputation? Sure. Lenders loan or make business credit cards all the time. They recognize the credit of a business. Another part of our MCLE presentation is the elimination of bias. And that's why I'm talking about this subject in this manner. What happens if an industry is biased against a borrower because of their race? What if the lenders refused to loan to people that were in neighborhoods that were unfamiliar to them, or that had small businesses instead of employees, or had people of black or brown or red or yellow or white skin? That form of wrongdoing may reflect bias. It might be a wrongdoing to be to show favoritism or to exclude certain groups from an economic enterprise because of bias. Can it be measured? Yes. It'd be just like another form of wrongdoing. But let's look closely at bias. I like the phrase invidious. Why are certain acts of wrongdoing, why do we call them invidious? What does invidious mean? You know, if somebody steals something from you, we can see that it's wrong. It may be outrageous. It might be, malicious. But we don't really use the word invidious when somebody robs another person on the street. We use invidious when it's something more subtle, but maybe even more harmful. Something that's hard to address, but maybe even more harmful.
Let's talk about gender bias.
Okay.
Until the Equal Credit Opportunity Act, women were not recognized as being important enough to have a credit identity. They had to have legislation. That's a bias. Now lenders bend over backwards to be sure not to be guilty of, or easily recognizably guilty of, denying a loan to a racial causation, a gender causation, or an age causation. All of those are biases.
Now let's keep the thought. But there's a kind of tie-in to expertise here. We're asking you to undertake this new profession, to become an expert at assessment. and it's a scientific enterprise. We're asking you to look at facts and apply a methodology, mathematics, that can be duplicated by others, and that arrives at an outcome that is appropriate. Now, why is bias a distortion? Why is it wrong? Why not have prejudice? We all have it. Why not accept it? White people should do these things. Black people should do these things. No, those red people should do these things. Leave them alone. Don't try to interfere. Let people be prejudiced. What's wrong with that? It's unscientific. It's not objective. It creates not a free market, it creates a distorted market. What are you playing on? You're playing on an unequal playing field. That's always inefficient. That's always going to result in injustice. Always. That's what an unequal playing field is. Why be rich and especially privileged if you can't have your special privileges? See? It distorts the marketplace. And the person who's on top there always wants to suppress the competition. And it's the competition that we rely upon to keep the changes modulated and just. If a competitor is not allowed to emerge, who has a better product, has a better idea, and they're nipped at the bud, their knees, the rug is taken out from under them, then we suffer. We all suffer. What's interesting here is that some brilliant people, 70 years ago, had this great idea that you could blame a group of people for the problems of the world. Scapegoating works pretty good. For who? It works real good for the people in power. They can say that the problems are due to this other group. Pick a scapegoat that is unarmed and can't resist, and preferably has some assets that you can steal from them. See, the Jews of Europe made a great scapegoat for the German Nazi party. Not Germans generally, but the Nazi party. Great scapegoat, because they were completely unarmed, and they had some assets. There were some Jews that had assets. Not very many in Eastern Europe. Most of them were really poor. But you could talk about their assets and just take their assets away from them, and they managed to. That became profitable. We see that today in the Middle East. Dominant groups have made scapegoats of minority groups, take their assets. It becomes a wonderful economic, but very short-term and rewarding enterprise. And what does it do to the marketplace? Do you have a free marketplace? No. You've distorted the marketplace. I want to talk about the science of Germany. Germany in 1920s was the most advanced country in the world, the most educated people, highly civilized. This is the country of Goethe and Beethoven and Schiller. They had the most PhDs on the planet. They had lived in peace, relative peace, for decades. In the First World War, whatever you think the cause of that terrible war was, it was entirely fought in France and Hungary and in places other than Germany. Germany did not suffer the actual experience of the First World War bombs going off in Germany. They felt successful. And the most civilized people on the planet were taken down by a group of thugs in a credit crisis, where credit was not valued, and where people who lost credit did not expect to recover from it. And a great thinker and sociologist and economist, George Simmel, calculated the move from trade goods to gold to coinage to cash to paper and finally to credit, he drew that history and showed that credit would be more convenient, more useful, and more valuable than anything else. He anticipated what we then saw 100 years later, and he was a German Jew. He was highly educated, and the Nazis destroyed him. We lost most of his work. And that is what we're looking at today, the recovery of credit through the expertise of experts to bring recovery of the credit losses that we have seen in history and we see today.
Now, you